Declare open this meeting of the Senate Economics Legislation Committee. The Senate has referred to the committee the particulars of proposed expenditure for 2020-21 and related documents for the Treasury portfolio and the Industry, Science, Energy and Resources portfolio. The committee may also examine the annual reports of the departments and agencies appearing before it. The committee has set 5 November 2020 as the date by which senators are to submit written questions on notice, and 10 December 2020 as the date for the return of answers to questions taken on notice. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. Officers and senators are familiar with the rules of the Senate which govern estimates hearings. If you need assistance, the Secretariat has a copy of the procedures. In particular, I draw the attention of witnesses to an order of the Senate of 13 May 2009 specifying the process by which a claim of public interest immunity should be raised, and which I now incorporate into Hansard. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to the public interest that could result from the disclosure of the information or the document. An officer called upon for the first time to answer a question should state their full name and position for the Hansard record, and witnesses should speak clearly into the microphone. Please make sure all mobile phones are switched off or turned to silent. I remind senators and witnesses in the hearing room that the microphones remain live unless I instruct otherwise, for example at suspension or adjournment. For witnesses participating via video conference, please mute your microphone as the default and unmute your microphone when speaking. I ask members of the media to follow the established media guidelines and instructions of the committee secretariat. As set out in the guidelines, senators and witnesses' laptops, mobile phones, other devices and personal papers are not to be filmed or photographed. Witnesses and senators who are seeking to table documents during the committee's hearings were requested to provide an electronic copy of these documents the day prior to the hearing, so that the documents could be circulated electronically during the hearing. Please liaise with the Secretariat if you need assistance. Senators, departments and agencies have been provided with advice on the arrangements in place to ensure that budget estimates hearings are conducted in a safe environment. This guidance is also available from the Secretariat. The committee appreciates the cooperation of all attendees in adhering to these arrangements. The committee's proceedings today will continue with the Treasury portfolio, beginning with the ATO and the Revenue Group, and the hearing will then follow the order as set out in the program. I welcome back Senator the Honourable Matthias Cormann, Minister for Finance. Also welcome Mr Chris Jordan and officers of Treasury and ATO. Minister or Mr Jordan, do you wish to make an opening statement?
Not me.
Not so much an opening statement, Chair, but if you could indulge me to simply say that I've come here today in face-to-face because it is Senator Cormann's last day of estimate hearings, and I just wanted to pay my respects to him and to thank the Senator, and I was fortunate with Senator Penny Wong before Senator Cormann to have someone of such capability to be able to support myself and my team in these hearings. So I just wanted to wish you the best. I won't shake hands, but for the future, and it's an honour to be here on your last day of estimates. I'm sure you will really miss it.
I certainly won't be back. Thank you. Thank you.
In that case, Senator McAllister.
Thank you very much. I wanted to ask the Treasury officials about the early access to super scheme. Is that something that I can ask you about, Mr Marco?
Yeah, there are aspects of that scheme that we cover, Senator, but there are other aspects which would be better covered off in Markets Group.
What aspects do you cover, Mr Marco?
We can probably speak to the actual outcomes of the scheme in combination with the ATO and in respect to the costing.
Right, okay. That's fine. So, program design?
Program design,
was
Markets Group.
Okay. Mr Jordan, you might direct me to one of your officials on these questions because it may not be you who needs to answer, but was any consideration given by the ATO in rolling out the early access to super scheme on the impact of women?
I'll hand over to Second Commissioner Hirshorn, who is responsible for our client engagement group.
Yes, Senator, we view this as a gender neutral policy. It's available to anybody who meets the qualifications, none of which are gender based.
There are a number of there's advice on the ATO website related to who can access the scheme and a warning to be aware of scams and schemes. Whose decision was it to include the warning about scams and schemes?
Sorry, Senator, I must admit I'm not, of course it was the ATO's decision. If you're asking for an individual officer, I couldn't say, but it is an area that we are very focused on across the normal tax system as well as any of the new measures. Across the world it's been considered that scammers are very interested in stimulus type measures.
In setting up the scheme, did the ATO give any consideration to including a warning about financial abuse in the context of domestic and family violence?
So, Senator, I'd have to take that on notice. On the top of my head, I do not think that we have put warnings about financial abuse specific to this measure on our website, but I'd have to take that on notice.
What is there anyone? I note that we've got quite a few officers on the call joining us from different locations. Is anyone who was involved in the scheme on the call?
I'm just trying to think. Deputy Commissioner James O'Halloran was Deputy Commissioner in charge of superannuation and employer obligations. However, he is probably not currently responsible. He may have something to add, but so James.
Mr O'Halloran, I'm interested to understand whether the ATO gave any consideration to financial abuse in rolling out the Early Access to Super scheme.
James O'Halloran, Deputy Commissioner, Economic Stimulus Branch, Senator and Chair. Whilst it predates any knowledge I have directly up until March of this year was when I changed roles, my recollection would be no, but I would have to take that on notice.
Is the ATO aware of any work being done in government on financial abuse?
No.
Does the ATO monitor for instances of financial abuse generally within your programs?
I suppose that's a pretty broad question, but I'm not aware of any.
Senator, we certainly are aware of, in a sense, in a subset of fraud. We do monitor for fraud by relatives. That is a subset of fraud across, just generally in the tax system and across schemes. So we do monitor for fraud. I couldn't point to anything specifically about financial abuse.
Does the ATO have an understanding of what financial abuse is in a domestic violence context?
Look, I could assume, I don't know if there's any particular definitional status or agreed position, but I could assume that would mean one partner putting pressure on the other to take funds out of their superannuation for the benefit of the other partner. I assume that's the sort of thing. Given, I mean, to give you an idea of the volume, on the 1st of July this year, we had 400,000 applications in the first day for the second lot of the 10,000 or up to $10,000. So in terms of any analysis of pre-issuance, that simply wouldn't be possible unless we were otherwise informed through the various channels of, there was I forget the name, a special channel set up for people to make complaints about stimulus measures.
Was the ATO involved in the consultation around the review of early release of superannuation benefits that was initiated in 2018?
James O'Halloran might be able to answer that.
Senator, if that's the Treasury inquiry your review you're referring to?
it is the Treasury review, Mr O'Halloran.
Look, and I'd have to confirm, but certainly we're aware of the review. We may have provided some information, but at this stage I couldn't recall what it actually was, but it would have been factual based on, facts and operational type matters. I thought there was public consultation, but I stand corrected, Senator and Chair, but that's probably my last memory of it. I apologise for that.
Thanks, Mr O'Halloran. There was public consultation. So it happens, in fact, that in the year before you're asked to stand up a new scheme for early access to super, there had been a public consultation about early access to super. And the Financial Rights Legal Centre Choice and Superannuation Consumers made a submission, and they talked about the proposals to allow early access to super for victims of family and domestic violence. And in their submission, they said that the grounds for this access would need to be carefully drafted so as to not create further opportunities for financial abuse or lead to unnecessary long-term financial detriment to the individual. So key consumer groups in 2019 are warning Treasury, and I think by proxy the ATO, of the problem of financial abuse, specifically in relation to the early access to super scheme. And your evidence today is that nobody thought about this or dealt with it, or I think even really understands the significance of financial abuse in the context of the early access to super scheme.
So
How
Senator,
can this be possible?
Senator, I would say that that's not, our evidence was not that. Our evidence is that we're taking on notice to check to see if it's taken into account. I don't think our evidence is that we have not taken it into account.
Mr Jordan isn't aware of any work of any kind to tackle financial abuse. You've provided evidence, Mr Hawshorn, that the ATO considers questions of fraud. Would you consider financial abuse to be a subsect of fraud?
So, Senator, I think we would view that as a subset of fraud in the terms of the context of people accessing other people's superannuation inappropriately.
Okay. So were there any protections? Why are there no protections? And were there any protections in relation to the early access to super scheme to prevent the early access to super scheme being used by abusers to exert financial control?
So, Senator, the main way of accessing the early release of super is to use your own MyGov account and make an application using your own MyGov account. And so if somebody is, Senator, the challenge is that if somebody logs in with their own MyGov account and meets the conditions, it is very difficult for us to work out if that is for somebody's own purposes or whether they are being forced to do it on behalf of somebody else. Of course, we have anonymous tip-off lines and the ability for people, even if they are forced to do the application, to actually ring us separately and say, I have been forced. I'm not aware of any of those cases having arisen.
I think you've got to, look, I mean, I don't want this to sound in any way harsh, but I think you've got to put into context here the stimulus measures of the government overall. Largely they were to get the money out to people in need as quickly as was appropriate with checks and balances. The sheer volume of people applying for the early release of super would have made it very difficult. I just don't, I absolutely understand the point you're making, but for us to know that person was subject to that pressure, I can't see, because it is through their MyGov account. And the sheer volume, if it wasn't, it's just the sheer volume. And at the time, the whole point of the stimulus, including cash flow boost, JobKeeper, etc., was to make sure we could get the money out to people in a quick fashion with appropriate checks and balances on that.
So is it appropriate for women's superannuation balances to be withdrawn and provided to a financial abuser. Is that an appropriate use of the scheme?
I would not say that in any situation, not this scheme or anything, that financial abuse is tolerable. So this is one opportunity of, that could happen every payday in a way.
But
So
you protect
I do not think it's
you
tolerable.
protect against other kinds of frauds and scams, and you have active measures to address those, do you not?
That was pretty much in terms of the identity fraud, because recall you go through the MyGov. If someone stole the identity credentials and took the money without that person knowing, that's fraud. And that is something that we were very cautious about.
But you made no design features, you built in no design features to check whether or not coercion was in play when money was being withdrawn. There's no design features that deal with that
There's
problem.
none that I'm aware of.
No.
And I'm unsure how, in the context of what was being done, we could have.
Do you
designed
monitor
that.
which bank account the funds go into when a person applies for withdrawal?
That is paid by the superannuation fund. All we do is say that that person is who they say they are, and then we notify the superannuation fund who make the payment. So the payment actually comes from the super fund, not from the tax office.
And you're not gathering or auditing or checking in any way that the scheme that you've set up facilitates financial abuse. It's not a feature of your work at the moment. Are you aware that Financial Counselling Australia's Chief Executive Officer, Ms Fiona Guthrie, has said that financial abuse is a concerning problem that has emerged during COVID-19? And she says, and this is a quote, "We have been getting reports of how the early release of super has opened up a frontier for people to financially abuse their partners. People know you can get access to super early, so they are forcing their partner to do that and use their money." It's shocking.
That's shocking. That's intolerable. We will certainly revert back and see what we can do now to find any examples or rectify that. But as I've said, the sheer volume up front would have made that very difficult to identify, because the person did use their MyGov identity and
Because you've
were
set up the
taken.
scheme in such a way as to not enable this issue to be tackled. You've set up a scheme on your own evidence without any obvious consideration being given to this issue, despite the fact that you were issued a very clear warning in a consultation undertaken on exactly this scheme less than 12 months ago. And that is my concern. Minister, who is it in government that is responsible for these issues? The Department of Women, the Office for Women say that they were not asked for any advice on this scheme before it was set up. Treasury can't tell me if anybody gave them any advice about the impacts on women. The ATO can't tell me that anyone gave any advice on the impacts of women. Is anyone in your government actually responsible for taking account of the impact of your policy decisions on women?
Our government is absolutely responsible, and we take responsibility, and I've gone through this in some great detail over the last few weeks. Every decision we make is focused on making sure that all Australians, including Australian women, have the best possible opportunity to dine into the future to get ahead.
Well, are you satisfied with the evidence you've heard just now about the way this scheme is actually working?
I'm
Minister?
satisfied that our government is motivated by making the best possible decisions for all Australians, including women. And at every election, I know that all Australians, including women, have the opportunity to pass judgment on how they value our performance and how they assess our plans for the future compared to the alternative. And at the most recent election,
I don't think we
the
can
Australian
wait for
people
an election
entrusted
is a
us, and we
credible-
will
a
continue to take
credible
responsibility for our judgments. Now,
So
in the
women have
context
to
of
wait till
this,
an election
well,
to
you can
fix the problem that
you
have
can
created.
try on
Order,
the
Councillor.
confected outrage. Let me just say that in the context of
This is
parliament-
not confected, Minister.
Order.
I am actually genuinely outraged.
Well, in any case, interjecting whether you're outraged or not. is
Let
not
me tell you,
appropriate.
in the last 7 or 8 months, we've been dealing with a 1 in a 100 year pandemic, which has had a devastating impact on economies around the world, including on ours, women and young Australians in particular were very severely impacted in the early months of the pandemic, but also, as the Treasury Secretary indicated yesterday, the jobs recovery has been stronger for women than what it has been for men, with the number of jobs 3.2% below they were at pre-COVID levels for women, compared to 3.4% below pre-COVID levels for men. We, of course, are focused to take every step possible to maximise the strength of the economic and jobs recovery, which is very important for women across Australia. Women across Australia understand what our government is doing to give them and all Australians the best possible opportunity to get ahead and to rebuild livelihoods after the very challenging situation we've been dealing with. Now, we've been working in a rapidly evolving situation. We've had to make some decisions very quickly at various times, whether, for example, with the design of a JobKeeper or the enhanced job seeker arrangements or a series of other measures. We knew that there were trade-offs because of the speed that we needed to respond with and the magnitude and the logistical challenges involved. And, in the end, I think that all reasonable Australians will accept that our government and all governments around Australia are doing the best they can in a very difficult and challenging context. And I don't think that trying to run this sort of assertive attack is going to help anyone in terms of delivering better outcomes.
Minister, are you saying that you are satisfied with a trade-off that sees women who are subject to family and domestic violence lose their super because you were in a hurry to design the program? Is that your evidence?
Well, no, that's not my evidence. I mean, that is, and it's not my evidence. I mean, that's just a completely unreasonable proposition.
Okay, well, are you satisfied with the explanation that's been provided today about the protections that are not in place, the absence of protections for victims of family and domestic violence in the scheme that you've authorised?
Well, I trust that the ATO and all agencies of government are doing the best they can to enforce the laws of the land as appropriate. And of course, in relation to domestic violence, we've taken very significant measures, including in the context of the coronavirus pandemic, to provide additional supports. And we will continue to review whether there are other things that we should sensibly consider to further ameliorate the situation. But quite frankly, there's a more constructive and less combative way to engage in relation to these matters in order to achieve sensible, productive, positive resolutions to important issues.
Mm-hmm. So do you think, Minister, if you'd asked for advice from the Office for Women before setting up this scheme, they might have told your government that there was a problem, a potential problem in relation to financial abuse?
Again,
But you didn't ask.
I'm not meaning to be unreasonable, but in the period February, March, April, we were literally making hundreds of decisions a day to keep the show on the road. And we were dealing with a rapidly evolving crisis situation. And there are a lot of procedural good practice elements that would be nice in a normal business as usual situation. But we were dealing with a crisis situation. And I think that reasonable Australians understand the circumstance we were facing and the context in which we were operating. It is a matter of fact that there was a need for speed, and I think Australians, and including and in particular women across Australia, who were disproportionately impacted by the initial crisis hit on the economy, appreciated the fact that the government responded quickly and swiftly in helping to provide support for as many of them as possible to remain in jobs and to provide the enhanced social safety net support for those who lost their job in this environment through no fault of their own, and all of the various other measures that we sought to take. Is every part of your response 100% perfect when you make rapid decisions in the context of a crisis with the benefit of hindsight? No, but I think that everybody knows that you need to accept certain trade-offs when there is a need for speed.
Well, that is some trade-off, Minister. Thank you.
Thank you, Senator McAllister. Senator Gallagher, are you seeking the call? Senator Betts is coming in at 9:30, and I'm going to give him the call then. So there's a 5-minute window for appropriate questions.
Yep, I'll try and.
Thank you.
Can I go to the immediate expensing initiative? Is that you, Ms DeMarco?
It is, Senator.
Okay. We've touched on this yesterday with the Secretary. But how much extra investment is this measure expected to create rather than just a bring forward of investment that would have occurred?
I think, Senator, a lot of those estimates in terms of the macroeconomic impacts are conducted by Macroeconomic Group, but we see the measures of temporary full expensing and loss carryback working together. They were designed to be mutually reinforcing, and sort of combined, the two measures are estimated to create around 50,000 jobs by the end of 21-22 and boost GDP by around 2.5 billion in 2021 and 10 billion in 21-22.
Sorry, 2.5 billion in 2021?
In 2021 and 10 billion in 21-22.
But you can't tell me how much of that would have normally occurred as opposed to being, in a smoother way than just being incentivised to be brought forward.
Sorry, Senator, I suspect I might have the answer, but those questions are best answered by Macroeconomic Group, but I'll see if I can get you an answer during the
That would
session.
be great, because
Yeah.
we didn't go to macro on that. There's no requirement to hire additional workers as part of using this measure, is there?
There is not, Senator.
So where you do your jobs numbers, can you talk me through that, how you get to 50,000?
Again, Senator, those estimates are conducted by Macroeconomic Group and consistent with the approach that they took you through, I think, yesterday with respect to the personal income tax.
Okay, so that's that 0.6.
I think there's different multipliers that apply to the investment numbers, but they're flowed through their standard macroeconometric model.
Okay. So there's no new jobs required, but then you've run your model, or Macro's run the model to come up with that 50,000 figure, and that works across both the loss carryback and it's full expensing.
That's right. It applies to both loss carryback and full expensing.
Which I think combined, so is that about 31 billion, is that right?
In combination?
Yeah, I think.
It's about right, Senator.
Yeah, okay. Now, tell me about this, what's happened since the budget. So there's been some concerns raised about eligibility for the scheme, and then there's a couple of media reports about how the Treasurer is open to reconsidering eligibility and urged Treasury to work with the BCA, I think, in one article. Can you give me an update of what's happened there?
Yeah, happy to, Senator. So I think consistent with an approach to a sort of a wide variety of programs across the economic response, we sought to design the legislation around existing definitions. So in this case, it was the existing definition of turnover, which has been successfully applied to a wide range of initiatives. It applies
This is the aggregate turnover.
That's the aggregate
Yep.
turnover test. So the instant asset write-off, backing business investment, JobKeeper, the existing differential rates in the corporate tax system, all use this existing definition of aggregated turnover. The Treasurer has asked that we consult with industry to ensure that definition is fit for purpose with respect to the full expensing policy, and where those consultations are currently underway with stakeholders.
Okay. So can you give me how are those proceeding, and what's your time frame for those concluding?
So I think thus far we've received representations from a wide variety of stakeholders, accounting
BCA?
firms, the BCA, accounting firms, individual entities, and we've sought to aggregate that feedback and will provide advice to the Treasurer in due course.
But this scheme's sort of operational for purchases from the 7th of October, is that right?
From budget night.
Yep.
Yep.
And the legislation's passed, and now we're looking at the design of the measure.
I think, Senator, I'd not necessarily characterise it as design. I think it's to ensure that in using these existing definitions, which is designed to ensure that you can get activity flowing as quickly, that it's capturing the full value of activity
Okay,
as
so
intended by the measure.
when I think on budget night or in some of the documents it says 99% of all businesses will be eligible for this. Is that correct?
That is correct, Senator.
So you're having discussions about the 1% that Treasury knew were excluded from this when the budget was put together?
Senator, I'd characterise it slightly differently in that the way that definition applies is to exclude global income. And I don't know if the ATO have sort of different advice on this, but there's aspects of how that is like information that only the firms themselves will know. And so, but we do not believe it a very large number of entities that are subject to this, but we have been asked by the Treasurer to take a look at the definitions to ensure that they are capturing all of the investment and activity as intended.
So what's the Treasurer worried about then? If the design was using this word aggregate turnover, widely used, has that protection of ensuring that, you know, there's some safeguards about who's benefiting from this incentive. What's he worried about? What is the actual problem here? How many firms are excluded? And I guess what's their claim to this measure?
So, Senator, I think as I said, we don't have clear data on those firms that are or are not, that are excluded. We do not believe it's a very large number, and indeed I think some of the numbers that have been in media reports have been...
It says about 100, I think, is it?
I think one has said about 100, one has said around 53. But again, these definitions we used existing definitions. They hadn't previously applied in some senses to measures on turnover scale that we're looking at here, and we're looking to ensure that they're fit for purpose, for the purposes of the measure.
Okay, and so it's between 53 and 100 at your best, but you don't really know. Is that right? If it's a widely used threshold or definition, why wouldn't you know? Like, why wouldn't you know who's not eligible?
So, Senator, I think there's a couple of aspects to that. I think the first is that what we do know is based on what's reported in income tax return data. And so global turnover isn't something that is reported on company tax returns. And that's the key distinguishing feature that we've been asked to take a look at or investigate to ensure that the measure's fit for purpose. I think...
But in terms of sorry to interrupt, but in terms of the instant asset write-off, if it's the same definition, you don't know who is ineligible for that either?
So, Senator, the instant asset write-off has been applying to turnover thresholds that are much lower than the 5 billion turnover threshold.
So this is the 5 billion.
Yeah, so once we're looking at entities above, we're not talking about a huge number of entities above these kinds of turnover thresholds, Senator.
Yeah.
They're much more limited.
Chair, I'm conscious that you wanted to go to Senator Abetz. I've got more questions on this,
Of
but
course.
if
We can come back to you. Thank you. That's very
just
helpful.
remember this,
Senator
Senator Abetz.
I will indeed.
Yeah.
Extremely generous, but more importantly, I think the chair is.
Gallagher. Eternal gratitude.
That's not the way you say things.
Because the chair controls the show.
Senator Abetz.
Thank
the way
you,
you say
Chair.
thank you.
On page 13 of the Lower Taxes Budget 2021 document, we're told about modernising and expanding Australia's tax treaty networks. And let me quote, the government will support the recovery from COVID-19 by modernising and expanding the tax treaty network to eliminate double taxation, settle taxing rights between Australia and other countries and attract foreign investment. As an aside, can I say, irrespective of COVID, I commend this initiative and its vital importance to the Australian economy in any event. It's important for us to diversify our foreign investment so we're not over-reliant on one source. So can I ask, what are we doing to expedite these important treaty opportunities? What's actually happening?
I'll hand over to my Treasury colleague. They actually look after the negotiation and finalisation of treaties.
So can we be given an example of a few countries with which we are actually engaging? How far down the track are we with them? I sort of want some confidence that it's not just a statement in a document, but actual work is occurring behind the scenes, and I'm sure you'll do that for me.
Certainly, Senator. Paul McCullough, Division Head, Corporate and International Tax Division. If I can give you a flavour of the sorts of things that this program will be looking at over time, there are two...
Well, don't say over time. I would like this to sort of be a bit quicker than over time.
It is a 4-year funded program,
All
Senator.
right.
That's all I was referring to. So over the 4-year period.
And that's a special fund to expedite this, are you saying?
Yes, there's
and how much is that?
$3.9 million has been
Great.
set aside. And essentially that's for expanding Treasury's commitment to a dedicated treaties negotiation project. And there are two elements. One is to look at the existing treaties where we've got obligations to renew, refresh, update, etc. And the second is to deal with a very large list of countries who are constantly approaching us to say, we would like to have a treaty with you. Now currently Australia's got 45 full double tax agreement treaties. It's got a whole range of other things to do with exchange of information agreements. We're very comprehensive on that regard, but the full double tax agreements only really apply to 45 countries. You asked for examples. We've got renegotiation requests that we will have to work through. I don't think we'll be able to get through all of these, but just at the last count, there were 14 from Austria, Chile, India,
If you can
Italy.
give us the list on notice, please, save time of the committee. Can we do them as quickly as the Minister did the one with Germany or not?
Well, I think part of the process, or part of the idea, we've got new requests. I was going to mention that there's 19 of those, and we've got 10 outstanding international
And
obligations.
can you give us a list of that on those
Absolutely,
on notice
yes.
as well, please?
Then we've got some legal obligations to renegotiate. They're triggered by most favoured nation clauses and that sort of thing. So I'll provide all that detail of all those countries on notice. Now, clearly, with the resources that we had been applying to these sort of things, and with the complexity of treaties, we wouldn't have been able to get through those. So we're effectively tripling, perhaps even quadrupling, when we draw from resources elsewhere to put the effort into this. We'll have to change the way we approach things too, in order to make sure we deal with the requisite speed, simply because we've been taking a very bespoke approach to each of the treaties. I think the idea going forward, and this will be subject to decisions of government down the track about which countries we're approaching, but the idea is more to have a model that reflects best international practice and effectively offer that to either countries that we are obliged to renegotiate with, or in fact to new countries, provided they have fulfilled their information exchange agreement commitments with us, and to provided that they've got some sort of very similar, or not very similar, a similar tax system. I mean, you can't really have a full agreement without changes if somebody doesn't have a personal tax system or a company tax system, whereas we do.
Look, you're telling us about all the difficulties, but after 4 years, $3.9 million of taxpayers' money, what are we expecting to have to show for those endeavours and that expenditure?
Well, we've set ourselves a target of eventually being able to do 4 or 5 a year by the end of the program. But the program builds up. The funding doesn't start in year one. It builds up over time. So possibly over that 4-year period, something in the order of 12 to 15 renegotiations would be possible.
United Arab Emirates, are we looking at them just to pick an example?
There would have to be a government decision, Senator, about who would be on the program. Certainly they've requested, but the question of who gets on the program needs to be, has traditionally been the subject of a cabinet decision.
But why do we need all this sort of infrastructure when we've already done these treaties with other countries? Why can't we just get on with the job of signing up and negotiating these treaties rather than talking about this framework that's going to be built over 4 years when we've already got examples, as the Minister so capably did with the German arrangement?
Well, the Minister's off on other duties.
Let me say, the upgraded and modernised double taxation agreement with Germany, a very good agreement, which was the first agreement which included the base erosion and profit shifting elements that were negotiated, through the OECD.
OECD,
yes,
very good.
Some time ago. So it's a very good agreement, and I would like to see it rolled out, as a template into other jurisdictions.
And Senator, if I've given you the impression that it's back-ended, that wasn't my intention. It does take place over the 4 years. I'm sure those responsible for it will be getting onto it as soon as possible.
So who's going to be held responsible at the end of this? For whom is at the key performance indicator? Minister, you will escape from any responsibility, regrettably. But who
Well,
will...
I have every confidence. I have every confidence that the Treasurer and the Assistant Treasurer and the government will deliver on the mission of finalising these agreements as soon as possible.
Yeah, but ultimately it's with the departmental officials as well driving it, and so is it you, Mr McCulloch, that we come back to in 4 years' time and say, you've spent $3.9 million over 4 years, what have you got to show for it?
It would be my deepest desire in one sense, Senator, because it's a thing I'm very passionate about. However.
All right. Look, understood, and I look forward to receiving that information that I requested on notice. Thank you, Chair.
Thank you.
A special thank you to Senator Gallagher.
Thank you, Senator Betts. That's the kind of manners we encourage in this committee. Senator
Allows for
Gallagher.
a much smoother day. Okay, so just to finish off on the full expensing, it's got different names: immediate expensing, temporary expensing, full expensing. We all use them interchangeably. Okay, so you've been asked to have a look for this very small group that have obviously raised issues with the Treasurer. Could you tell me what their issues are? Is it just that they're simply excluded from the scheme and they would otherwise spend loads of money? Is that what they're saying? But they're not going to now?
So, Senator, I think on the basis of the definition of aggregated turnover,
Yep.
they're not eligible for the scheme. And I mean, by design, in circumstances where you do have an uncertain macroeconomic outlook, where the health outcomes are playing very significantly into the economic outlook, you're looking to maximise the amount of business investment that we can attract, increase the capital stock, creates more jobs down the line. And so we're just looking to ensure that the definition, as I said, we've used existing definitions consistent with the Minister's advice before on other matters. We did used to look to leverage existing systems so we could get activity underway, and we're just looking to ensure that it remains fit for purpose to capture the full value of investment.
Okay. But any change would require a trade-off, essentially, of some of the other protections that the definition affords.
So, and we actively work with our colleagues in the ATO to ensure that any changes we do make ensure integrity of the tax system that the definitions are designed to protect against.
Have you, I mean, for the Treasurer to ask you to have a look at it, it must have raised, some level of concern from his point of view. Can you give me, do you have an understanding of the scale of the investment that's perhaps not being made, wouldn't be made if they remained ineligible? Do you have any idea of that, or is it, I mean, because look, let's face it, if 45 to 100 small businesses raised this concern, I'm not sure that you would have been asked to reassess the definition. So I presume that the Treasurer has been told these groups or these firms would use it and use it on a large scale. Is that correct?
Senator, I'm not sure we've received an account from entities about how much they would or wouldn't invest. But I think the point is that what we're looking at is a number of firms who have significantly mobile capital bases, and they can choose to locate activity in many different places globally. And we're looking to ensure that the scheme as designed attracts that investment in Australia, particularly against the COVID-19 backdrop where we're looking to increase investment levels.
Okay. And when do you think, because the rules aren't out yet, are they? I mean, that's the tax office, isn't it? That has to, well, what, Mr. Marco, you have to settle this, do you, before you can put the rules out? Or the formal guidance that happens? I note on the ATO website it says more information coming soon.
So, Senator, the tax office is currently starting to administer the law that was passed.
Right, so you're not going to provide any more information soon? That's your website that says that.
We'll continue providing advice as people need on the law as has been passed. If the law changes, then we will administer as the law has changed.
And Mr. Marco, can the Treasurer remind me the legislation that passed, does it give the Treasurer the ability to change the eligibility?
Any changes would require legislation, Senator.
Okay, so it's not like the JobKeeper or the hiring credit, which I think are being drafted in a way that sort of gives the Treasurer the full, sign a reg and change everything. It would have to come back to the Parliament if you were going to do something.
That's correct, Senator.
And you don't have a time frame on that?
I think the Treasurer's asked us to resolve it as efficiently as possible.
Okay, and just finally, is it any new information that's come to light by these firms that has caused the Treasurer to want it reconsidered by Treasury? I mean, is there any specifically new issue that you weren't aware of before? I presume you looked at this when you were suggesting the way the program should be designed.
I think, Senator, as I alluded to before, the way I would describe it is they are existing definitions. They have typically applied to measures and turnover thresholds that are much lower. And having used those existing definitions, some of the aspects of how they would apply at scale, he's asked us to consider what changes, if any, we could make to ensure it captures as much investment as possible.
Okay, all right. Chair, I have some other questions. I don't know if you
Feel free to
want...
continue,
Okay.
Senator Gallagher.
All right, thank you. You're responsible for Statement 5?
I am, Senator.
Yeah, okay. Okay, I've got some questions about that. In terms of personal income tax, there's a couple of tables in the budget documents and the fact sheets which go through, which measure, sort of give a snapshot of what people in different income thresholds, the changes in their tax liability and the relief they get under the tax changes that have passed with stage 1 and stage 2. And then there's one table where you bring in 24, 25. I think that's on one of the fact sheets rather than the glossy. I can't give you a page number, but are you aware of that table where it brings single person household change in household tax paid?
I'll just have a look through the fact sheets, Senator. I know there's a wide variety.
Yeah, there are.
Oh, yep.
Yep.
Yes.
So in those tables, particularly well, actually, they're constructed in an interesting way, actually, because in that one it's got 18, 19, and then it jumps to 22, 23, 24, 25. actually.
I think, Senator, if you're
That's
talking
from-
about the table on page 17, Appendix A,
Yeah.
yeah, I think that's just describing the actual structure of the changes to the rates and scales as the personal tax plan is rolled out.
Okay. Because if you have a look at what people would be paying this year, so in 2021, with Lamito and the Leto, or however those work, comparing tables, so if you compare for people on incomes from 30,000 to 80,000 in those income thresholds, if you compare what they will be, the relief they'll be getting in 24-25, they will be getting less relief there than they are in this 2021 year. Is that correct?
So, Senator, I don't think it's published in here the changes in relief for the 24-25 year, but I think it's important to sort of describe the kind of structure of the tax plan and how that's been rolled out for this budget. In particular, I think as the Secretary referenced yesterday, there's essentially two pieces to the enhanced personal tax plan announced in the budget. The first piece is a classic stimulus measure, which is the doubling of the Lamito. So we're providing an additional Lamito payment for 2021. And the second piece is bringing forward phase 2 of the personal tax plan.
Yeah.
And so it's important to think about what the structure of that tax plan is. So the Lamito is legislated, provides targeted and temporary tax relief of up to $1,080 for those on less than $126,000.
Yeah.
Phase 2 then structurally locks in those benefits of the Lamito. But in doing so, it does change the rates and scales which flows through the entire income distribution.
Yeah, I understand that there's two things happening in this financial year, but perhaps if I go back, when I look at, for those, the median taxable income can you give me the median taxable income for this year?
For this year?
Yeah.
I don't have that on me, Senator.
Okay.
But we'll see what we can get.
All right. Well, can you tell me how many taxpayers are in that 30 to 90,000 thresholds?
So, Senator, what I can tell you, what I've got in front of me, so
Yep.
around 40%, so for the 18-19 income year,
Yep.
around 40% of Lamito recipients were on less than 48,000,
Yep.
and around 45% of Lamito recipients were between 48,000 and 90,000. That's of Lamito recipients.
Okay. But you don't have, that doesn't give me an idea. What's the percentage of taxpayers that exists that are in that lower income brackets? So 90,000 and below.
So I don't, oh, that's the Lamito numbers. Hold on.
Okay.
The number of taxpayers, Senator?
Yeah.
Less than 37,000 is 2.3 million. Between 37 and 45 is 1.3.
Yeah.
Between 45 and 48 is 480 million. And between 48 and 90,000.
480,000.
480,000,
Yeah.
sorry, yeah. Sorry, Senator.
Yeah, you're right.
And between 48,000 and 90,000 is 4.6.
Okay. Okay, and so, again, when you look at, for those taxpayers in those brackets, if you look at what they'll be paying in 24-25 versus what they're paying in 2021, those taxpayers will be getting less tax relief in 24-25 once stage 3 kicks in than they are in this tax year.
As I said, Senator, I think you need to, I would caution against double counting the stimulus piece that's going out for the 2021 income year, which is very much, as Secretary described, in the form of classic stimulus. Their actual tax outcome will depend on where on the income distribution they are, as there is a change and an increase in the threshold.
I understand there's two things happening, but Ms DeMarco, I mean, do you think that taxpayers themselves who will be getting this relief will be separating those things out as, I mean, for them, the reality of the tax relief they get this year compared to once the stage 3, with the tax plan kicks in entirely, they will be getting, you know, to them, in terms of income into the household, they will be getting less tax relief for taxpayers 80,000 and below. Correct?
So, Senator, again, one part of it flows through withholding.
I
which
understand
is,
I understand your explanation, but the practical effect of that is that for those low-income households, they will be paying more tax in 2024-25 than they are paying in this tax year. That's my reading of the budget documents.
So,
Well, perhaps it's a question to the Minister.
What's that? What's the question?
You weren't listening to that
I was
scintillating
listening,
line
but
of
I'm just
questioning.
wanting to make sure that I'm answering the right question.
That for taxpayers, 80,000 on incomes $80,000 and below, will be paying more tax in 2024-25 than they are in this year. They actually. There we go. I wasn't listening.
So you are mixing up.
No,
And
I'm not
I think
mixing
I
up.
think Ms. DeMarco
I'm
has
not
I
mixing
was
up.
listening very carefully. Yeah, you are mixing up.
I'm not
Ms.
mixing up.
DeMarco has actually, I mean, I was listening to her answers very carefully.
Yeah.
So we've made a decision to effectively double the value of the tax relief in this financial year as a stimulus measure. And you are holding that against us to say
No, I'm
that
not.
because we're not keeping the doubling of the tax cut in place on an ongoing basis, that somehow is a tax increase. That is precisely what you're doing. We have made a decision, the low and middle income tax offset, of course, was meant to finish, and because it was going to be absorbed into the tax scales on an ongoing basis, it was going to be reflected as part of the revised income tax rights as the full legislated plan was coming into effect. But because of the decision to bring income tax relief forward to 1 July 2020 as per the budget measure, we made a decision to extend the operation of the low and middle income tax offset by a further year, which effectively doubles for that income bracket that you're talking about, the value in that year. And you're saying, well, because you're not making that ongoing, that doubling of the tax relief, somehow that means that down the track, that's a tax increase. That is completely and utterly
If you're a
unreasonable.
household on $80,000 or below, my reading of your budget tables are that you will be paying more tax in 2024-25 than you will be in this financial year.
It's
It's
just
a
not
pretty
true.
easy question to answer.
Well, no, but I have answered the question, and I mean, this is like saying, because we give two $750 one-off payments to various recipients of pension payments and the like, because that is not an ongoing $750 payment. That's like suggesting that we are cutting the payments, in future years, which is of course not true. I mean, it's just a ridiculous
Will they be
proposition
paying more tax,
to sort of.
Minister?
No, they won't.
They won't be.
No, because I mean, you are seeking to distort the effect of a one-off temporary
I'm not seeking to do
additional
anything
fiscal stimulus
other than
measure
look at your tables.
to draw from it like a conclusion that is inaccurate.
I'm looking at your tables in the budget paper.
Well, I mean, you can repeat that assertion as many times as you like. It's not true.
Okay. In terms of the stage 3 tax cuts, have you done any work on recosting those for
You
base?
don't recost previously existing measures. You only cost the effect of an adjusted measure. And so the costing was in relation to the fiscal impact of the bring forward. I mean, you don't recost like previously legislated measures because they are reflected in the bottom line already.
But if you read, okay, but if you read chapter 5, you are basically saying because lower wages, a large part, my reading of chapter 5, when you talk about essentially your reduction in revenue is due to lower wage levels resulting in a reduction in average tax rates and taxation receipts as a share of the economy across the medium term. So you don't have to adjust anything then? No. In light of the fact...
Well, not in relation to previous policy measures. What you assess is the impact of changes in economic and other parameters on your revenues across the various categories, but you don't recost specific policy measures that were previously in previous budgets and have already been legislated. The policy settings are what they are, and there is an economic impact clearly, and when economic growth is less than previously anticipated because of a pandemic, or employment growth is less, or what there are variances in wages growth that might be higher or lower than previously anticipated, then all of these things get obviously worked through a model in terms of how they impact on revenue or payments for that matter. And that is reflected in Budget Paper 1, Chapter 3, where it talks about the estimates variations or the impact of parameter variations on revenue and payments.
Yeah. Okay. So if I just stay in chapter statement 5, when you're talking, what's the total write-down of revenue is 283 billion, is it?
That's total variations, but that includes
That's
policy.
parameter variations, policy decisions.
That's correct. So just parameter and other variations is 227 million.
I did write that down somewhere. And of that, I was writing this. Yes. Chair, could I maybe go to Senator Watt? Or
You can. I was thinking of checking whether Senator McKim is on video because I know he had questions in this section. Are you there, Senator McKim?
oh, what a shame.
Doesn't look like it. In that case, Senator Watt.
Sorry,
yes.
I've just got to find my place.
No, that's fine.
Yeah.
Thanks, Chair. I've just got a few questions about JobKeeper, and I know we've talked about this before. Obviously, the purpose of JobKeeper is to maintain the link between an employer and an employee. That's correct? Yep. I've just had a couple of instances reported to me, and I just want to sort of get some sense of the legality of the situation. So, is it possible or appropriate for an employer to require an employee to take leave without pay and then be paid JobKeeper?
Senator, this is a question which is outside our bailiwick. Would be more for Fair Work. From the tax office perspective, as long as the employee is paid $1,500 at least in a fortnight, that meets the tax side. The industrial relations elements are more for Fair Work.
Right, so your concern is simply whether the money is passed on to the worker?
Absolutely, Senator.
Right. Are you aware of circumstances in which an employer or an employee has received JobKeeper having taken leave without pay?
Senator, I'm sure there are cases. I couldn't.
Yeah, I'm just trying to get an understanding of whether that's okay or not. And it may well be, I just don't know how JobKeeper works.
So in many cases, many people on JobKeeper were originally stood down completely, which is in a way, you could say is equivalent to a leave without pay in a sense, like in a let's say in a layman's sense, maybe not from an industrial law sense. JobKeeper was very much designed so people who are fully stood down would receive JobKeeper. Again, from our perspective, once they're paid the $1,500, we don't. It's not so much our concern as to, in a sense, what they're being paid for.
Okay, and is it appropriate or even legal for an employer to pay an employee JobKeeper even if that employee never intends to return to the job?
Yes, so Senator, as long as the employment contract is still in place, the employment relationship is still in place, then JobKeeper can still be paid as long as the employment relationship is in place. So if the person resigned or terminated the employment contract, either side terminated the agreement, there would be no more JobKeeper. But if the employment contract still exists, even if in a sense it is dormant and may never be reawoken, then JobKeeper can still be payable.
So, and I suppose the reason I'm asking this goes back to that purpose of JobKeeper, that it's about maintaining that connection between an employee and an employer. So, if an employer, if an employee essentially gives notice or expresses an intention to leave the job, but the employer, for some reason, perhaps even to sort of manufacture a termination style payment, if the employer encourages that employee to obtain JobKeeper, having signalled their intention to resign, surely that can't be legal.
So I would say, again, if somebody has ended their employment relationship, there is no more entitlement to JobKeeper, and artificial schemes around JobKeeper entitlement are also not allowed. So if it was indeed in reality a termination dressed up as a JobKeeper tail, then we would be very interested in applying the scheme provisions.
That's what I was thinking, is that if there actually is no real intention to preserve that employment relationship, then surely that goes against the intent of JobKeeper.
Yes, Senator. Now, of course, intents are often not communicated and their intents are not action, but in the scenario that you draw out, which is where somebody has in reality terminated their employment relationship and are somehow pretending that relationship continues to get an ongoing JobKeeper tail, we would be very interested in, and we would be seeking to apply the scheme provisions.
Right. And what are the if that is indeed illegal, what are the consequences of that kind of action?
So generally, where a scheme is found, the JobKeeper will be able to claw back the JobKeeper that is paid, and with significant penalties.
Penalties for the employer?
Yes.
Right. And the employee?
So potentially the employee is jointly and severally liable.
Okay. And is it legal? I know that JobKeeper can't be paid to government employees, whether it be federal, state, local. Or foreign.
Foreign government.
I'm not going to go there. But what's the situation in terms of government-funded workers? So if a worker in an organisation, whether it be private or community sector, whether that position is funded, if that position is funded by government, can JobKeeper be obtained to support the wages of that employee?
Depends on the turnover.
Yes, so Senator, the structure of JobKeeper is that it's on an entity-by-entity basis. So the turnover test is and whether the company has met the test is at the entity level, so has it had a sufficient reduction in turnover? Once it has met that, all continuing jobs are potentially supportable through JobKeeper.
Right.
So we don't trace jobs.
Yep, and the funding source of them. So if it's a government employee, foreign, local, state, federal, no JobKeeper.
Correct.
if it's a government-funded position, assuming the other tests are met, JobKeeper can be paid.
Yes, so JobKeeper could potentially be paid. Obviously, businesses which are primarily government-funded are very unlikely to meet the turnover tests because the government funding will be not have that sort of diminution.
Yep. And again, given the purpose of JobKeeper is to preserve those employment relationships, I think I've asked you this question before, but I just want to confirm, if JobKeeper is paid to a political party and then those funds are not used to maintain someone's employment but are instead funneled away, for instance, for campaign purposes, that would be a breach of the JobKeeper scheme?
Yes, so, and Senator, I'll respond in the abstract,
yes,
of course.
Yes.
That, again, we care about whether the entity has met the turnover test and whether the employee has been paid at least $1,500 for the fortnight. As long as those conditions are met, we don't sort of trace the JobKeeper the actual cheque money to where it goes to. If the employee was not being paid the $1,500 in an continuing employment arrangement, we would be very concerned. If the employee is still being paid more than $1,500, you know, we don't track the cheque.
But surely, leaving aside which party, if it's Labor, Liberal, National, Greens, whoever, if a political party obtains JobKeeper on the basis that their turnover has decreased and they've met all the relevant tests, and if that funding is intended to support the wages of that party's employees, if those funds are then diverted and used for an entirely different purpose, such as campaigning, that would have to be against the spirit and the intent of the JobKeeper scheme.
So Senator, again, I'd say as long as the employee is being paid $1,500 a fortnight, that meets the tests. So if I was to draw that out, and if an existing employee was being paid $2,000 a fortnight and the turnover test was met, there's no requirement that the $2,000 is topped up to $3,500. It's entirely appropriate under JobKeeper to leave the salary at $2,000, and that subsidy of that employment can then be used by the organisation.
But that's the point, isn't it, that the subsidy has to be used for that person's employment. I'm not talking about using the money to top up someone's wage.
The entity must still pay that employee at least $1,500 a fortnight.
Right, okay. I'm not going to ask you for a lot of detail on this for obvious reasons. You'd be aware I've referred some allegations involving the Queensland Greens to
Senator,
the ATO.
We have received those, and as with all referrals, we treat them very seriously.
And are you able to advise me, I don't know exactly what the process is, whether it's a desktop review, which if something meets a certain criteria gets elevated to a formal investigation. Are you able to let me know where that's up to in the stage of things?
So, Senator, I cannot, other than to assure you that we have taken the tip-off seriously, and that action, appropriate action is being taken, has been taken. I just would go back to a general comment, a very general comment, that in many cases, employees feel that or their understanding of JobKeeper is that they should be topped up by the $1,500 and do not realise that they have no entitlement to be topped up if they're already being paid more than $1,500 in a fortnight.
No, and I'm not aware of anything involving that in this situation. So this matter is under investigation.
Yes, so Senator, we generally don't confirm specifically, but I will confirm that we've received your complaint and the appropriate action is being taken off that complaint.
Thank you. That's it for me.
Thank you, Senator Watt. I think we do have Senator McKim now. Senator McKim, are you there?
Yes, Chair, I am. Thank you. And I wanted to ask some questions about the money laundering case and the settlement between Austrac and Westpac. And just ask, please, the ATO, given the agreed statement of facts in Austrac's case against Westpac states that Westpac's actions, and I'll quote from the agreed statement of facts, risked undermining the Australian taxation system. Can you just please give us a précis about the potential implications of Westpac's failure to report 19.5 million international transactions worth $11 billion? What are the implications on that failure to report on our for our taxation system?
Yes, so Senator Jeremy Herschel, Second Commissioner. So money, and I might answer at a slightly higher level of abstraction. Information that we receive from AUSTRAC under anti-money laundering legislation and what are called suspicious matter reports are a very important information source for us in tracking international tax evasion, amongst other things. And so if we are not receiving that information, there is a chance that we will not detect international tax evasion that we might otherwise have detected.
All right, thank you. Was that the case this time around with Westpac's failure to report?
So, Senator, in the abstract, of course, any information around suspicious matters going cross-border has the potential to involve international tax evasion, and it's fair to say that money launderers and criminals are often not the most diligent in their tax reporting processes. I cannot comment on what action we've taken in relation to the information we have subsequently received.
All right. The agreed statement of facts says that 5.7 million of the 19.5 million transactions that Westpac failed to report in accordance with its legal obligations were made outside the ATO's statutory limits. What statutory limits are we talking about there?
So, Senator, I must admit I'm not familiar with that part of the report, and I wonder if that's referring. There's an AUSTRAC $10,000 limit. I'm not sure if it's referring to that, but I'm not familiar with that part of the report. I would have to take it on notice.
All right, thank you. I'd appreciate that if you would. I know you've said you can't comment on specifics, but I'm just going to ask you a couple of questions anyway, and if you want to repeat that answer, obviously you will. But can I ask whether there are any further transactions that Westpac made that you can't act upon in terms of the ATO's response?
So, Senator, once we get, as a matter of course, we get information from AUSTRAC of suspicious matter reports, and we feed those into our intelligence and risk systems. Obviously, we do not act on every one, but we do feed them into our systems. So anything which does not go into our systems obviously we can't take detection action in relation to that. I couldn't tell you offhand or probably at all how much activity has been taken from those that Westpac has reported in the past or those that Westpac is now reporting. I'm sorry, I don't have that information, and indeed under secrecy I would probably not be able to tell you in any event.
All right. Perhaps I could ask you this then. Has the case that AUSTRAC took against Westpac prejudiced any action that the ATO could take against Westpac, or is the ATO free to pursue Westpac if you believe you have a prima facie case?
Yes. So, Senator, the AUSTRAC, in short, the AUSTRAC action is the AUSTRAC action. It does not really interact with us. I might just clarify. We are the information which we will obtain from AUSTRAC in relation to these cross-border transactions. We are interested in that in relation to the tax affairs of the transferors and transferees. Yep. We are not interested in the context of the tax affairs of the bank.
Why is that?
Senator, in a sense, because it's other people's money. So it does not go to Westpac's profitability. If in a sense,
Westpac might be charging a small fee
That's right.
on that transaction that presumably goes into their normal revenue. But
So that's
we'd
income
be
for
interested. They take a fee on international transfers. We'd be interested much more in the people paying and the people receiving, as was said.
All right, I understand why you may have, I guess, priorities of interest, but the point you just made was the one I was going to make, which is that presumably Westpac does profit from these transactions, and there was obviously an awful lot of them that were relative to the AUSTRAC case. So is what you're saying that the ATO doesn't believe that there was any possibility of tax avoidance from Westpac here in regards to these cases?
So again, Senator, it's very difficult to talk about specific cases, but I would say in the abstract, we are very comfortable that large corporates in Australia, such as the big four banks, when they book profit, they pay. They book profit, they pay tax on it. We do not have concerns that they're somehow hiding the profits from this activity offshore in some way.
Or do you have concerns that they may be failing to report it?
So
the profits, I mean?
So, Senator, again, in an abstract sense, large corporates in Australia have very good governance around booking their profits. This would be, if they were not booking profits, that would...
I don't know. I mean, Westpac didn't have very good governance around reporting transactions, did it?
Again, Senator, I would say that it's the distinction between reporting around information on other people and reporting on their own information.
Yeah, but they're both legal obligations. And they abjectly failed. They abjectly failed at one of those legal obligations 19.5 million times, enabling pedophiles and terrorists while they were doing it. On what basis does the ATO have confidence that they're meeting their other tax reporting obligations?
Okay, so Senator, if I might just do a segue. So our confidence comes from our experience and our actions. So under the Tax Avoidance Task Force, we received over the last few years about $1.7 billion to focus on the largest companies. That allows us to have one-on-one reviews every year with the top 100 companies. Obviously, the big four banks are part of the top 100 companies. In fact, they're part of the top 10 companies. We spend a lot of time with them, and we have high assurance that they are doing the right thing in relation to their tax. That's our aim. Our experience is that large listed corporates do not participate in tax evasion. When we have disputes with them, it is generally around whether certain actions are tax avoidance or transfer mispricing. Can I say our experience from intense interactions with these companies is that they do not evade tax. Some might try to avoid it, but they do not evade it.
Yep. All right, thank you. Westpac have been embroiled in Operation Atlantis through their correspondent banking relationship with Euro Pacific. I understand the ATO had a role in Operation Atlantis. Can you just outline that role in general terms?
Yes, so Senator, and of course we have not confirmed that Project Atlantis involves any of the parties mentioned on the recent 60 Minutes. We have not confirmed that. So Operation Atlantis is an operation of a group called the J5. It is a group of 5 revenue authorities, Australia, US, Canada, UK and the Netherlands. This was a large joint operation between those revenue authorities, recognising that some promoters are, they do not choose one jurisdiction, they act globally. I might pass over to my colleague, Deputy Commissioner Will Day, who is responsible so he represents the Commissioner on the Serious Financial Crimes Task Force and is also our delegate, our lead delegate to the J5, if there are further detailed questions.
Sure, Mr Day, did you wish to add anything in overview in regards to Operation Atlantis?
While he's settling in, Senator, I should say that the J5 came out of the Panama Papers leak. Australia very much drove the analysis and the collaboration between many countries, and it was evident that trying to continue to do that with so many countries was a bit unwieldy. Hence, those 5 were formed to maintain a close relationship under this JITSIC program, which I'm the sponsor of as Commissioner for Australia, which is subset under the auspices of the OECD. The OECD has the Forum of Tax Authorities in Australia.
Very important organisation.
And the OECD, being a very important body, the OECD has a secretariat for the FTA, and we work very closely with the OECD. But the J5 was formed out of that very large data leak.
Oh, thank you.
Will Day, Deputy Commissioner of Taxation. So as the Commissioner and Second Commissioner Hirshhorn have explained, that the Joint Chiefs of Global Tax Enforcement, or the J5, works closely with the Serious Financial Crime Task Force in Australia. We were formed the J5 was formed on the 1st of July 2018, so we've recently had our 2-year anniversary, and as Chris has said, it came out of a call to arms from the OECD to do more about international tax crime. So we've had more information exchanges over the last year or so than we have, so cumulatively over the last 10 years. But the focus of the J5 certainly is operationally. We do have a number of investigations and operations underway involving 2 and often more of the 5 countries. In particular, in January of this year, we did have an unprecedented day of action across all 5 countries involving subpoenas, search warrants, interviews and so on. As Second Commissioner Hirshhorn has explained, we have not confirmed who is or who is not within scope of that major operation. That's because the operation is ongoing, so investigations are ongoing. We are looking at criminal, civil and regulatory action. But because of the secrecy requirements and operational requirements across those 5 countries, we're not in a position to confirm who is
But we think
who's not.
there is around 100 Australians as a result of that are of interest to us at the ATO. Other countries in that J5 also had perhaps more. It was a focus on some of these enablers that set up institutions in some locations that are what we call secrecy locations.
Thank you. Thank you. And when I think it was Mr Day said that the operation is ongoing, is that relating specifically to Operation Atlantis?
That's right, Senator. So Operation Atlantis is continuing across the 5 countries, and there are a number of other investigations and operations at the J5 as well.
All right, thank you. You mentioned, I think it was you, Commissioner, that there were about 100 Australians of interest in regards to Operation Atlantis. Are you able to say how many Australian companies are of interest to that operation?
I'd have to take that on notice, Senator, but we are looking at around 100 taxpayers, that's right.
I mean, generally you'll find, as Mr Hershon said, very large companies don't hide money away. They want to show profit. They want to increase their profit for the purposes of reporting and decrease their taxable income. So you'll tend to find that this is more in your high wealth individual market, and they might have companies, but it will be high wealth individuals sitting behind the company as a beneficial owner.
All right, but you can say that, Commissioner, but Euro-Pacific was a correspondent bank for Westpac. Euro-Pacific basically advertised tax avoidance services, and Westpac engaged in a relationship with Euro-Pacific. Are you able to inform the Senate in terms of Westpac's correspondent banking relationship with Euro-Pacific? Like, for example, when did that start? Is it still going? And if it's not still going, when did it end?
And Senator McKim, that'll have to be the last question before the break.
No.
No, you're not able to tell the committee that? Or no, you don't know?
Well, for secrecy and ongoing operational reasons, we can't confirm specifics about particular entities.
Okay, the committee will now break and will return at 10:45. Okay, the committee will now resume. Senator Rennick.
I've got a couple of questions. You'll probably have to take them on notice and come back to me. Could I get the costings on what Section 855.10 of the 97 Act costs the government? It's the CGT-free profits on non-portfolio interests held by foreigners. Do you track that at all?
So, Senator, I think we could perhaps, my Treasury colleagues could perhaps go back to the original costings of the measure.
Yep.
And I could see what information we have on exactly how, if we've got information from tax returns.
Yeah, that'd be good, if you could, thanks. And likewise, the costings on 2690, which is the interest deductibility for Australian multinationals who invest offshore against their non-assessable, non-exempt income.
Yes, Senator. And I think that it might be Section 2590, but...
2590, sorry, it is, yeah. And also, does the ATO track shares that are shorted by institutions to ensure that they're not shorted for longer than 12 months? Do you have a mechanism for tracking that in the tax return?
So, Senator, we do not have a mechanism for tracking that in our tax return. We are interested in our compliance activities around derivative positions around shares.
Yep.
Particularly in the context of shares which pay franked dividends.
Yep.
Because sometimes derivative strategies around those share portfolios are designed to generate artificially high franking credits.
Yep.
So we generally track this as part of our compliance activities. We have, I know we have for very large companies, we have a specific question in the tax return, something that's called the reportable tax position schedule.
Yep.
Which asks if people have entered into particular types of structure, one of which is a derivative-based structure.
Yep.
But we generally do not ask that information in the tax returns. We cover it through compliance.
I'll take that up with our guys, but that's something I think we should track because there's a lot of shorting goes on, and if it's held for longer than 12 months, it's supposed to be treated as a capital gain. And I suspect that it's not because it's not being tracked. There could be something worth looking at. And likewise, with 128F, the public offer test, do you also audit the holdings of those bonds to make sure they weren't bought on the secondary market rather than the primary market?
Yes, so again, Senator, yes, we are often involved at the start of a 128F issue.
Yep.
And then it will be tracked through our normal compliance type activities.
Okay then, great, cheers, thank you.
Thanks, Senator Rennick. Senator Gallagher.
Okay, thank you. Mr Marco, we've got, you said the loss carryback works in partnership with the immediate expensing. Why, I'm right to understand that sole traders and partnerships aren't able to access this measure?
They aren't able to access the loss carryback aspect of the measure, that's correct, Senator.
Yeah, and so can you explain why that is?
Senator, I might actually ask Mr Thompson to come to the... No? Mr McCullough to come to the table, sorry. Wrong one of my colleagues to talk through that.
Sure.
Senator Paul McCullough, International Tax Division. Your question was why?
Yeah, why was the decision
taken? Doesn't
yeah.
apply to non-corporates.
Yep.
Well, I mean, the first part of the why is decision of government, but if you look at circumstances where, say, by comparison with full expensing, lots of businesses have depreciable assets, whether they be in a corporate structure or a more complex, medium, smaller business structure with, say, corporates, trusts, or indeed whether they be a sole trader. Mm-hmm. And for loss carryback, the difficulty is when you get into these complex structures outside corporate arrangements where you've got trusts, where typically trusts don't accumulate profits. And remember, the notion of loss carryback is to take the loss from this current year back against a profit of a previous year.
Yes.
So when you've got a trust in the arrangement, the profit hasn't been kept there at all. It's actually been distributed to the individuals. So when you get into a situation of potentially carrying profits back outside of corporates, where you've got a clear measure of profit and you've got a limitation that they've still got to have retained that profit rather than distributing it, you get into all sorts of technical difficulties, compliance problems down the track, etc. And also, when this had been tried before, that was a limitation that was applied previously, and so the limitation was applied this time, as I understand it.
So fundamentally, Senator Gallagher, I mean, there are integrity issues here, and as Mr. McCulloch just quite rightly said, when this was done incidentally, under the previous Labor government, it was framed in the same way, and for very good reasons. I mean, once you make it more widely available to that extent, I mean, the level of opportunity to abuse this measure, would be very significant in a very undesirable fashion.
So from what I'm hearing, it's complicated, but it's also an integrity measure.
Yes.
What proportion, in the small business sector, what proportion are sole traders or partnerships? Do you have that information? Or can you answer how many small businesses are excluded or not eligible for this measure?
I might have that, if you can give me a moment.
Perhaps that would be excellent.
Just have to look. I may not be able to find it quickly, Senator. Can I?
Sure. We're here all day and all night. That would be useful, I think. And in terms of the jobs estimate to be attached to this measure, I don't think I've seen a specific one. I've seen it's 50,000 jobs generated, according to the government, for the immediate expensing and this. I think that's right, from previous evidence. And so there isn't a separate jobs number attached to this specific measure?
No, they're regarded as integrated, and indeed, to some extent, the loss carryback is complementary, excuse my throat, to the immediate expensing. There is a potential that some of the companies, some of the entities that are taking up full expensing would therefore be put into a loss situation because of the tax circumstance, which they couldn't benefit from without the loss carryback. But no, there's no separation.
All right, so it's
of the two
50,000.
figures.
And how do you, out of interest, how do you measure? Well, you've come up with a figure, I think, which is linked to the sort of fiscal multiplier. But then, how do you monitor that? Is there any way to, in a year's time or 2 years' time, to say, yep, it did exactly what we thought?
I think that's probably one for my other colleagues, but it's typically very, very difficult to look back over a suite of changes in a very complex economy and say precisely this number of changes occurred because of this measure.
Yeah, okay, so...
But it is possible in advance to look at the aggregate stimulus effect and look at those questions of multipliers that were discussed in previous evidence and say, this is the broad range of number that we would expect.
Yeah, okay, so it's easier to predict, less clear about what's actually delivered by it.
Well, it's easy to measure in the aggregate, but to try and say this job was created by this measure after the fact is very, very difficult.
And you wouldn't do that? You don't do that at all? I don't think Treasury will try to acquit against these job predictions, will they?
No, there's... in the budget process, there's never been a sort of a...
This is what we said,
an
this is what we got?
reconciliation against measure by measure. No, it's all really looked at in the aggregate and the parameters.
Mr McCulloch, is this your area also on the lifting of the, the small business concessions where you're increasing thresholds and eligibility for certain tax concessions. Is that your
I know
area?
that would be my colleague, Mr
Okay.
Thompson.
Okay. I just have a couple of questions. Sorry for the musical chairs.
Hector Thompson, Acting Division Head, Individuals and Indirect Tax Division.
Thank you, Mr. Thompson. So can you just tell me, when you say when the measure is you're lifting the threshold from 10 to 50 million, how many small businesses will that bring into these new, businesses that will be able to claim new tax concessions?
Sure. I recall that number in some of the documentation. I'll just... So, around 20,000 businesses, Senator.
So there's around 2 million small businesses in Australia, is that right? And I don't know if you've got a more up-to-date figure than that.
Depends on how you measure it, Senator.
Yes, it
there's
does.
There's up to 3.6 million
I know.
under
There's
one.
a lot of definitions.
But there a lot of people doing part-time business activities.
Yep.
So they might have a job but do something on the side. So
Yep.
3.6 is at the way upper end. But how many do we count?
I think, Senator, we would generally count it as about that 3.6 to 4 million sort of figure as businesses out there, of which about half, a bit less than half, are sole traders, which might include contractors.
So 3.4 million.
3.6 to 4 million, depending, like that sort of range.
Businesses.
Small businesses.
Small businesses under, yep. So what's your threshold for that?
Okay, so I think
it
that has
10,
historically been the 10
50?
million. That's historically been the 10 million
Yeah,
turnover.
that's the issue. So that's 10. Okay, so under 10 million. So for those small businesses under 10 million, they don't get any additional benefit from this measure because they already get it.
That's correct, Senator, because
Okay.
they're already eligible for these concessions.
So so are you happy with the tax office's numbers that they've just given me?
Yeah, broadly. So it's about 3.5 million under 10 million out of a total of 3.535 million.
Okay.
But don't forget, a lot of those are those sole IT contractors, people from labour hire firms. Like, there's a lot of.
So of that 3.6 to 4 million, how many are sole traders?
I think it's about half.
It's going to be about half.
Okay, so
Just
that
an
brings
order
us
of
back
magnitude,
to
it's about
sort
half.
of the more traditional measure of 2 million small businesses. It also shows how many aren't eligible for the loss carryback too, I think, if you're using those figures. All right, so there's the vast majority, are already under 10 million, so this doesn't provide any additional benefit for them. And so the measure, the small business concessions, pulls in another 20,000 businesses into that threshold.
Correct.
And that has a cost of, so just over $100 million.
Correct, Senator.
$100 million to bring in 20,000 businesses. Okay. All right. That's that on that one. Thank you. Can I just have some? I'll just check. I've got a few questions. I'm trying to do it so I'm not jumping officials around too much. Mr. Marco, I think I need you back at the table. I've got some questions from Statement 5 that I found.
Apologies for the musical chairs, Senator.
No, it's my fault. I'm trying to see if I can stop moving people, but... And then I've got some for the ATO. All right. So, when I look at statement 5, and I wanted, it's genuinely just wanting to see if I'm tracing the impact correctly. So parameter and other variations has a negative impact in the order of 227 billion across the forward estimates. And then when you add in with policy decisions, that's what brings it up to 283.5 billion. When I then look at the impact of individual tax withholding, that says 108 billion across the forward estimates from lower earnings, essentially, lower earnings impacting on lower tax receipts. So can you say that of the 283.5 billion, 108 billion of that relates to individual withholding tax, or tax withholdings, however you say it?
Sorry, Senator, just so I make sure I'm tracking where you're looking at the table on page 510 and then having a look at the breakdowns that are articulated in page 514?
Yeah.
Yes, that's correct, Senator.
Okay, so a large amount of the revenue write-down is just from people earning less, working less, and therefore paying less income tax.
That's correct, Senator, and that reflects a substantial proportion of our tax base that is in fact individuals' income tax withholding.
Okay. When I look at your table 3 there on 510, can you talk me through the compensation of employees? Because it seems to me for your forecast years, the final 2 in the forward estimates, is that a genuine forecast, or is that just reverting back to, some fixed long-term estimate?
The 4.25?
Yeah.
No, I think that genuinely reflects the transition path back to full employment that Macroeconomic Group have undertaken as part of updating the forecasts.
Okay, so it's quite different. I know it's measuring different things from the wage price index in the economic forecast, but they don't have this kind of, going from 3/4 to 4 in 1 year. Like their trajectory in terms of, wages is much smoother along the lines of sort of the unemployment rate and other labour data that's got a gradual recovery. When you look at table 3, that means we got an extraordinary turnaround in 22-23 back to a longer term picture. And when I go back to the MyEFO, in MyEFO 1920, you had compensation of employees 4 3/4 in 1920, 4 1/4 2021, 4 1/4 21-22, 4 1/2 22-23. So I guess I've got 2 questions, or 3 maybe. Why is it so different to the major economic parameters? Why is have you changed it so dramatically to drop it in 2021 and 21-22, but then go back to a extremely high or a very quick, substantial change in 22-23? Maybe I'll leave it at those 2 first.
So I think the first thing to say, Senator, is the compensation of employees figure is entirely consistent with the macroeconomic outlook in Chapter 2. So compensation of employees is impacted by quite a few things. It's impacted by heads employment, it's impacted by hours worked, and it's impacted by average weekly earnings.
Yeah.
And so it's the combination of those 3 things that gives us total compensation of employees, which we then flow into the tax tax outlook for individuals and income taxation. So I don't think there's any inconsistency. I'm happy to sort of take on notice a more detailed articulation of those components of the breakdown in a consultation with macroeconomic group.
Okay.
But I don't think there is anything. Where you see the change in profile reflects that economic recovery and the path of recovery, particularly through the labour market, and then that how that flows through to earnings and wages.
So what happens in 21-22 that takes compensation of employees from 0.75% to 4% in a year? Like, what is the change there? Perhaps it's breaking down what's in that 4%, what contributes to that 4%.
Yeah, and I'm happy to take that on notice, Senator. My suspicion is that it relates to the rebound in the labour market.
Okay, and I'm not suggesting it isn't worked through with macro.
No.
I'm sure that, you know, people working on the budget have a look at this. But the reason it stood out to me is that the rebound in the labour market in every other table is it's moving in the right direction, but it's not a snapback situation. Like, it's quite a gradual recovery, and we're still, you know, by the end of the forward estimates have, you know, 5.5% unemployment, and so it seems at odds with other information.
I think it's because the total compensation of employees, as I said, reflects quite a combination of those macro parameters, not all of which are articulated in here. So you've got the heads employment piece, and you do have the employment growth numbers articulated in table 2. It's page 1.8 over the forward estimates. But what you've then got is also average weekly, but you basically multiply those heads by average weekly earnings. And that average weekly earnings does reflect the numbers that you see through WPI, but it also reflects things through hours worked and other changes in composition in the labour market. So I'm very happy to take on notice the breakdown between those two factors that's driving the recovery.
If you could perhaps explain of that. I'm particularly interested in what you're seeing in that, in the difference between 21-22 and 22-23. Like, what are the major movements that shift that so dramatically?
Very happy to, yeah.
Okay. Let me just see if I've got... So overall, when I read this chapter, you are predicting, or you are forecasting that revenue is going to remain lower, in fact 1 percentage point lower than what was expected in December last year until the end of the medium term.
That's correct, Senator.
Being, medium term being 30-31?
Correct.
Okay, so less revenue coming in for that whole for 10 years essentially. All right. I think I've done with chapter 5 or statement 5. I've got some questions for the ATO.
Yep. Happy for you to continue, Senator. I'll go to Senator Patrick next, and then I believe Senator McKim has one more bracket.
Oh, do you want to go just... Yeah.
Sorry, Senator, I just wanted to check. I've got a couple of answers to some of the questions you asked previously. I thought I'd revert on. So you asked what the median wage was. So in 2019, it was around 57,000.
Yep.
And then in terms of the investment response, as a result of the full expensing policy,
yep,
the direct investment response is 21 billion over the 2 years. I don't have the breakdown in front of me in terms of how much is additional and how much is brought forward, but I think reflecting what the Secretary was talking about yesterday, our colleagues in macroeconomic group have taken a fairly conservative approach to having a look at those multipliers. I think certainly these kinds of policies against the uncertain backdrop that we've got do a lot to support confidence and encourage the investment that's already in the pipeline to actually take place.
Yep.
And in terms of how you go ex post and take a look at these sorts of things, I think as Mr McCullough said, typically that is done on aggregate, and you have a look at the suite of measures brought to bear and the impact that they have. But I think yesterday my colleagues also referred to a very good paper by the Reserve Bank of Australia a couple of years ago, which actually had a look at sort of separate impacts of the investment allowance policy around a decade ago. And that can give you some kind of insights into the relative multipliers
But you'll be able to
applied.
measure, if you've got a figure of 21, was it 21.6? Or did you say 21 billion?
It's around 21 billion.
Okay, so you will be able to see whether that actually is what's, that is, you'll be able to see through interaction with the tax office whether that is actually the investment that's brought forward or that's utilised through this measure over 2 years.
In total, we expected to support around about 200 billion, and I think that's laid out in the budget papers. The question then really is what's kind of the investment response and the inducement effect of it,
Yeah.
and certainly we will be looking
You will
to...
be able to track that, yeah, okay. All right, do you have information as part of putting this measure together about what you expect, like industry by industry, business size by business size, who you expect will utilise this, and what are the top sectors? Do you have that?
I think, Senator, as discussed yesterday, these tend to be done at an aggregate level. They're not done on an entity-by-entity basis or on a sector-by-sector basis. We do have some information on what sort of sectors we're investing in depreciable capital in 17-18, which I'm happy to provide. At the table. Thanks. So for firms with total income of under $5 billion, investment in mining was around 22%.
Yeah.
Around 15% was in rental hiring and real estate services. Around 10% in ICT. And then 5% each in a range of sectors from manufacturing, agriculture, transport, construction, professional, scientific and technical, finance, electricity, gas, water and waste, and wholesale trade.
Okay, so you would expect that to be similar?
I think, that
Yeah.
reflects a variety of things.
Yeah.
It reflects their share of economic activity. It reflects their capital intensity. We certainly haven't projected that they will look any different, but these things can change year on year.
Was there any thought given to whether we should be pulling in any human capital development as part of this measure?
As in requirements with respect to that?
No, like as whether they could utilise it for, productivity improving, investments in their people.
To immediately expense it?
Like it's not part of the measure. Is there? It's probably one for the government though.
It might be one. It might be one for government, Senator.
But Senator, if I might add that most costs of developing the human capital of your employment for employees is deductible up front already.
Yeah. Okay.
And indeed, there was a measure in the budget that exempted fringe benefits tax, businesses for fringe benefits tax for retraining as well.
Okay. I'm happy to go to Senator Patrick and then come back.
Okay, thanks, Senator Gallagher. Senator Patrick.
And thank you, Senator Gallagher. A couple of questions, a couple of simple ones, just in relation to tax avoidance, tax evasion, and the statement of tax record. That's businesses or government suppliers to government for contracts over $4 million will seek to obtain from you a statement of record. Now, my understanding is that when that statement of record is processed, you will look for, is it registered as an ABN? Has the applicant lodged 90% of their income tax returns, their FBT, their GST, with some reasonable allowance for delays agreed by the tax office, and that they don't have a debt of greater than $10,000? Is that kind of about the right?
Yes, so Senator, I probably don't have that level of granular detail in front of me, but yes, so in the statement of tax record, we focus on 3 of the 4 OECD pillars, and I hesitate to say OECD again today, but there are 4 pillars. Yes. So one is registration. Is somebody in the system? One is whether they are lodging. The fourth is whether they're paying.
Yeah.
The third is whether they are reporting correctly.
Yeah.
Under the Statement of Tax Record, we focus on the three which are, in a sense, objective
Yeah.
and non-contestable, which is the first, second and fourth. We do not focus on whether the tax return as lodged is correct.
Which comes to my next question, is that government departments can't, whilst it's a good measure, government departments can't rely on that Statement of Tax Record to make an assessment as to whether someone is involved in aggressive tax avoidance or unlawful tax evasion. Is that a correct statement?
Yes, so, Senator, and this was an important design feature because as much as I would like it to be...
I'm not criticising, I'm just trying to understand...
So it was really important because as much as I'd like us to be infallible, the tax office is not infallible. My auditors are great, but not infallible. And so the thought was, if we start bringing in, is the tax return lodged correct? We're not affording somebody due process in real time. But so, in a sense, a government procurer must, in a sense, rely on the fact that the ATO will be competent and do its job and eventually catch up with that taxpayer. But it will not be something that we can feed into a real-time procurement decision.
Can you provide, perhaps on notice, how many Statement of Tax Records have been requested and provided since their introduction? I think it's the 1st of July 2019, so for the last financial year.
Yes, so Senator, I will take that on notice, but I can tell you that the detail I have in front of me, that it's about 9,000 applications have been received.
Okay. Okay, thank you. Second line of questioning, Facebook. When you, and I do this from time to time, when I seek to boost a post, on my private credit card I get a return saying it's X amount of, a couple $100 or something, and then it goes to the international transaction fee, and it's clear that that money is going to Ireland. I only boost around South Australia, perhaps to particular areas that might be interested in something that I'm doing. I have a concern that people in Australia are paying for Facebook ads, for Facebook boosting, and the money is going straight to Ireland and somehow escaping our tax system.
Yes, so Senator, if I might, if I can touch on that. So I'll talk first about the domestic measures that have been done in relation to that sort of business, and then I might touch on a little bit on the international discussion that's going on, and might even pass over to my colleague on the international aspects. And again, I apologise in advance, we are going to have to mention the work of the OECD. So it was identified that a range of companies were abusing the current international tax framework. And the current international tax framework has been that you get to tax, let's say Australia gets to tax sales activity, or let's say business activity which occurs in Australia. So we sometimes say sales in Australia, but we don't get to tax sales to Australia. And so the same reason when Australia sells iron ore to China, China doesn't get to tax BHP on the iron ore sales. The same way, inbound advertising services are not, if they're sold to Australian businesses or to Australians, as compared to being sold in Australia. It was identified that some of in particular the tech companies, were abusing that process to artificially avoid having a permanent establishment in Australia. So they would set up a bunch of people here who were almost like introductory agents for the Irish business.
Yep.
And say, well, they get compensated on cost or cost plus, but all the sales are being done out of Ireland. Now, the government brought in the multinational anti-avoidance law, which is directly aimed at that form of permanent establishment avoidance, artificially avoiding a permanent establishment. What that meant is that if I take it to a tech company selling advertising, where that tech company has people on the ground involved with advertisers, so that's generally with big businesses, or if they have a direct sales model in Australia, Australia is now taxing those profits. and that they've brought about $8.5 billion of sales each year into Australia, into the Australian tax net. But where there are sales which are not intermediated by anybody in Australia, so in inverted commas, if a Facebook has no Australian employees helping you with your advertising and it's actually being done from offshore, under the existing international tax framework, Australia has no right to levy income tax on their profits. We also, under another measure, which is sometimes called the Netflix tax, we do have the right to collect GST on those sales. So that was a big change. In the past, there was no GST or income tax. There is GST. So this has been recognised as a feature of the international tax system, the incumbent system, which is perhaps less relevant in a digital world. And this has triggered off what's called the BEPS 2.0 initiative being run under the auspices of the OECD. And they have recently suggested an alternative basis for taxing some of those profits. For example, the profits from selling advertising to a local business directly from overseas. But on the status of those discussions, I might pass over to my Treasury colleagues.
Yes, Senator. The process that my colleague Jeremy Hirschhorn has been talking about has been going on for probably a couple of years now. It was one of the last ones of the BEPS agenda, as it's called, to be implemented because it is really challenging. Mr Hirschhorn has talked about the two elements, the income tax element and the consumption tax element. Australia is, or has implemented already, effectively world-leading treatment on the indirect tax side, the consumption tax side. This debate now turns to the income tax side, and that basically divides into two categories. One, which they call Pillar 1, very creatively. How should the profits of a multinational trading in a whole range of jurisdictions, selling products into those jurisdictions and making profits according to who buys them, which country really has the right to the lion's share of those? And the proposition, I mean, this is a very complicated thing, but I'm putting it in very simplistic terms. The proposition is that since the profit is generated from the consumer element of the economy, then that fraction should be taken into account when calculating the profits. In other words, if you're selling in, say, a US company selling into India or someplace with a very large population, then some portion of their profit should be reallocated to the Indian jurisdiction. So that's the Pillar 1 concept. Now, there's a lot of details, a lot of exceptions, a lot of components. The second component, Pillar 2, simply says that we're it's effectively a global minimum tax idea, and it says if somewhere along the chain somebody hasn't applied, some jurisdiction hasn't applied what we regard as being the minimum level of tax, then that should be topped up by one or the other of the participating countries. And together these two ideas have been pursued. The OECD has made a mammoth effort to produce, just last month, about 400 pages of design for these two pillars. It went to the G20 finance ministers a couple of weeks ago, where the minister was actually our representative, and they endorsed the idea for further negotiation, but the timetable that had been set for the end of this year, due to COVID and a range of other issues, was just not achievable. So they've effectively said, well, let's look at it by mid-2021.
Okay.
And Australia's an active part of that. Our Permanent Deputy Secretary is part of the steering group on the inclusive framework, and we participate in 4 of the working parties that support all this.
Hopefully that timeframe will come down when Senator Cormann's in in charge. So, can I, thank you, that was very, very helpful. Very quick question, when will the tax transparency data be released this year? It's not going to have some COVID delay. I live for this, so...
So, Senator, the plan, as far as I'm aware, is that it will be released at the same time as was every year. So around about the first or second week of December.
Okay, thank you. And my final line of questioning relates to the tax determination TD 2019 D11. Just wanted to, is this tax determination solely focused around Lend-Lease, or is it more broadly dealing with an issue that can be exploited or is being exploited?
So, Senator,
without prejudice to the...
So, generally we would do, if I think about our hierarchy of guidance products, we would normally do a tax ruling which is binding when something affects a lot of people.
Mm-hmm.
We would generally do a tax determination when perhaps it's a more niche issue which affects a few people. If it was only affecting one participant, we would generally do a private ruling.
Yeah.
We would rarely go through the process of a taxation determination if it was affecting one taxpayer. Sometimes though, when we go through processes, we realise that what we thought was a broader issue is actually a narrower issue.
Mm-hmm.
So it's fair to say that this issue is not a widespread issue. I'm not. It's not affecting many taxpayers.
Okay, so you would then say it's inappropriate for you to answer this next question potentially. I'm just understanding what's the quantum that is at risk in respect of whichever way this thing goes.
Look, I think it's very hard for me to comment on that. And the other thing I would say is that action against particular taxpayers is independent of the issuing of final determinations.
Sure. So, look, my understanding is from public domain information, Mr. Michael West has written about this. It's not in the millions. It's more in the billions that we're talking about. Is that fair?
Again, Senator, from public domain information, it is a significant issue. Look, again, you have access to the same public information as I can talk about.
Okay, all right. How many submissions has the ATO received in relation to this tax determination?
Senator, I'd have to take that on notice. I know we have received at least a few.
Yeah.
From a range of professional bodies.
Okay, and they're professional bodies that are representing a client's interest, or is it?
So generally professional bodies, when they do a submission, we accept it as a representation of that professional body.
Mm-hmm.
We do not... if a professional body is making a representation specifically on behalf of a taxpayer, we would expect them to disclose that. There have been times in the past, not just on this issue, maybe not even on this issue, there have been times in the past where professional bodies rely on the volunteer efforts of members, and particular members might be particularly energised about a particular issue, and we have seen from time to time professional bodies get caught in the position where they've got a submission which is really a specific submission rather than a true view of the professional body. But these representations have been made to us in good faith as being on behalf of the professional bodies.
Sure. I mean, there are some stories out there. I just wondered, have you had any submissions that have been either withdrawn or updated substantially in relation to this tax?
So, Senator, I'll take it on notice, but I'm aware of at least one which was withdrawn and a substantially different version was provided to us.
Okay.
It's also fair to say that submissions that we generally receive rarely say that we haven't gone far enough.
Yeah, okay. Can you just perhaps indicate, very interested in the comment you made that there is a requirement to declare an interest in respect of a submission.
Yes, so
are you satisfied in this particular tax determination, that there are no issues in respect of that principle not being followed?
So, Senator, I'm not aware of any evidence that that has occurred. Of course, when we read submissions, we listen very much to because we're after the right answer. We're not after as they say, the job of the tax collector is to collect the right amount of tax, not a penny more, not a penny less. In some cases, some submissions we might give less weight to their arguments.
Okay, and finally, when is this tax determination likely to be made, and what's the hold-up? I mean, this is an internal process?
Yes, so...
Does it involve legal submissions? What?
Yeah, so in moving from finalisation of a draft determination to the final, we'll generally take submissions and we'll have internal consideration. One of the challenges in finalising any sort of public guidance is that it's binding, but also that people will use it perhaps in other contexts, perhaps in unexpected ways, and so we have quite a degree of quality control before we finalise a determination. In some cases, we might realise that the determination is really only applying to one or two taxpayers, in which case we might say we can put the determination on hold, finalising it maybe on hold or maybe abandon it, and say that the right course of action is to just continue the dispute with a particular taxpayer. So there's a variety of reasons why a determination might slow down. Again, as I say, the timing of the determination is independent of the timing of action against individual taxpayers.
So, Senator Patrick, I've got to go back to Senator Gallagher and Senator McKim.
Sorry, I just didn't get the when part of my question there. Or are you going down the pathway of perhaps abandoning?
At the last hearing, I indicated, or at the COVID hearing, I indicated that I was very hopeful that it would finalise before the end of the year. Since that meeting, I've been advised caution by some of my colleagues, so I can't give any further update on the timing.
Okay, thank you, Chair.
Thanks, Senator Patrick. Senator McKim, are you there?
I am, Chair.
You have the call for about 10 minutes, then I've got to go back to Senator Gallagher.
All right, thanks. I wanted to ask some questions about the temporary loss carryback facility, and I know that's been discussed already this morning, but my first question is, has there been any estimate made of how many companies that use that facility will actually not trade their way back into profitability? In other words, what percentage of companies that use this facility will end up going broke anyway?
Sorry, Senator, I'd have to take that on notice.
All right, thanks. So I guess as a follow-up question to that, is it possible that this facility may end up in public funding being used to, for example, eliminate bad debts for banks, and then the company that receives the public funding goes broke anyway, and the only outcome is to reduce the level of bad debts for credit providers, including banks? Is that possible?
Sorry, Senator, could I just ask you to repeat the question? I think, unfortunately, there was a door noise in the background.
Oh, sure, sorry. So my question is it possible for the temporary loss carryback facility to result in public money being used to pay down bad debts for banks, while the company that received that money ends up going broke anyway? Sorry, is there some noise there that I can't talk over?
No, thanks. I'm just having a quick look at my colleague to work out who might be best to answer that. But,
Senator, just thinking through your question, the starting point, of course, is that it's tax that has been paid before that's being refunded. So whether you regard that as, I mean, it's a definitional question as to whether that's public money, but
So just set that aside for a minute. I do regard it as public money because before this change is implemented, that money sits with the government.
Well, that's fine, Senator. I'm simply saying that it's not immediately obvious that that's the position that we start from. But assuming it is, then there comes a question of, well, if somebody has received this, so if they've had profits before, they make the loss, they get it back, somehow as a result of that, creditors have been paid, but perhaps not enough to ultimately mean the business comes back as a full-blown going concern, etc. That's a possible outcome. It's possible that somebody could get their tax back and then not recommence ultimately trading.
All right, thank you. And along the same lines, is there, besides the pre-existing conditions in the Corporations Act, is there any impediment to a company using funding obtained under the temporary loss carryback facility to pay dividends?
Pay dividends.
Yeah, well, they use money that they receive from the temporary loss carryback facility to pay dividends and then go broke anyway.
Well, there's nothing in the tax measure specifically about what must happen to the money after the money has been paid to the company, so that would be a matter for the Corporations Act, etc.
So, Senator McKim, something very important to remember here. I mean, this is essentially a measure that provides cash flow support to businesses that were profitable before the crisis and are likely to be profitable again after the crisis by bringing forward the deduction of losses. So, I mean, this is a timing issue more than anything. I mean, we're bringing forward cash flow for businesses at a time when they need it most in order to give themselves a fighting chance to recover. And by applying it based on companies, that were previously profitable, we are targeting it to those that have the best possible chance to again be profitable into the future. But, and of course, over time, once the loss has been washed through the system, so to speak, it is no longer be available to be claimed in the future. And consequently, future taxable income will be higher than it otherwise would have been, and much of that revenue will be recouped, over time.
Thanks, Minister. Look, I'm going to move to my next topic. I might put a couple of other questions in on notice, but just in the interest of time, thank you for those responses. I wanted to ask Treasury about some of the assumptions that underpin the budget in terms of the price points and quantum of coal exports. Well, firstly, just to kick us off, I know that in the terms of trade, you have outlined the price assumptions that you've made for various key commodities, iron ore, metallurgical coal and thermal coal. But can I ask what assumptions you've used in terms of the export quantities of those resources in order to arrive at the figures that you have?
Sorry, Senator, those numbers are put together by our colleagues in macroeconomic group, so I'll have to take those on notice.
Okay, so that's not put together by revenue?
No. We take those inputs from macro group and convert them into revenue estimates.
Okay, well, I'll put a series of questions in on notice in that case. What about gas prices? Would that fall into the same category as the work done by macro?
It does, Senator.
All right, thanks. In that case, I'll go back to my questions on loss carryback. I think we've just established that the monies obtained by businesses under the loss carryback facility can be used to pay down debt, even if the company at some stage goes broke into the future, which would mean public funds have been used to eliminate or reduce bad debts for banks. I think we also said agreed that money used under obtained from that facility could be used to pay dividends for shareholders. I just want to put a scenario to you and ask if this is possible. Let's assume that the company involved, obviously it's made profits in the past, it's now making a loss. Let's assume that company does have obligations to creditors. What is there to stop directors and creditors from restructuring their debts, effectively sharing the cash refund? Some goes to the creditors, some goes to the directors, some paid in dividends, some's paid to pay down debts. But if the company's going to go broke anyway, both the creditors and the shareholders will be better off than they otherwise would have been, thanks to this facility. Is that correct?
Well, Senator, the idea that somebody can deduct their losses against profits that they make in the future is a key feature of the system. All this measure does is says instead of waiting until you get the profit, you can have it now. So it's not fundamentally changing any of the rules about
timing difference.
It's a timing difference. Thank you, Minister.
But it's a timing difference in the context of a crisis when you actually have to provide. You've got to find sensible ways to provide cash flow support to businesses now. And in terms of the fiscal settings of the government, it actually also strengthens those moving forward because it flushes those losses through the system now rather than having them hang around over an extended period into the future.
Yeah, but your assumption, Minister, is that these companies are going to become profitable.
Sorry to interrupt, Senator Kim. This has to be the last question because I have to go back to Senator Gallagher.
All right, I'll put some questions in the notice, Chair. Thank you.
Right, that's very helpful. Thank you, Senator Kim. Senator Gallagher.
Thank you. Just got some questions about the R&D tax incentive measure. Just quickly. Minister, I understand you'd like a recall day. Putting in a special request for one.
Well, maybe make it the 1st of November.
Your smile has been getting larger and larger all morning. I feel like we've let you off too easy.
I do. I've done my fair share, I think.
Okay, so we'll make it a final 15 for you. The R&D tax incentive in the budget, just can you explain that we've had the legislation in the Parliament which has been seeking to cut the R&D tax incentive by 1.8 billion, which I think had fed through the forward estimates. Is that right?
That's correct.
So in terms of additional expenditure, is it the 2 billion for this year, or is it just an extra 240 million?
So probably the best way to answer the question is just to reflect on the legislation or the bill itself, which identified both the cost relative to established policy, which is the figure that you would have seen in Budget Statement 2.
Yep.
Budget Paper 2.
Yeah.
But also identified the impact relative to current arrangements, which was the 240 million figure that you referred to.
Okay. Can you just give me quickly a page number on BP2 under Treasury, I guess?
Okay.
Sorry.
So that my version doesn't have page numbers on it.
No, it's all right. I'm in the Treasury section. Is it in Treasury? Okay, so can you give me, just in short, acknowledging that we want to get done by midday, what's the additional money?
Well, I probably, so there's a range of changes to the tiers of payments. There's changes around the minimum or the maximum payment that's the maximum expenditure that's allowed to be claimed, and the removal of the cap on refundable R&D payments. So I don't believe I can identify, I'll just check with a colleague, I don't think I can identify the individual cost of each of those elements.
Okay, but you're removing the cut, so the cut reverts back to what it was before, and then you're topping up a little bit to make a $2 billion package. Is that correct?
So the bill or the current law retains the intensity test that was recommended in the 2016 review.
Yep.
But it provides different levels
Okay.
relative to the previous proposal, and the base amount is set at a rate that for under 20 for the refundable component and for claimants above 50 million aggregated turnover, they're no worse off.
Okay. Could you perhaps, just in the interest of time, provide on notice? I actually can't find the measure in BP2. I don't know if anyone else has found it.
I'll be able to find it.
Yeah. But perhaps take on notice what the changes are, and also, will the old bill that has the cuts coming in, will that be removed from the notice paper? Like, is that gone now? You know, this is the R&D tax incentive.
Well, I mean, that's
the one that's got the cuts coming in.
We're going to replace what is currently, on the notice paper with a new reform bill.
Okay,
I
so
can
it'll go.
confirm that. Yes.
That one will go. All
Yes.
right, thank you.
And it's on page 19, Senator.
Oh, right, okay. I was looking in the wrong section. Oh, right, because it's under job maker. Okay, might come back to it. All right. Just for the ATO, in the administration of JobKeeper, it's been reported that more than $1 billion in JobKeeper wage payments have been withheld during the pandemic, as the tax office investigates concerns about workers' eligibility and potential for rorts or, misuse of funds. Have you got an update on that, or is that?
Yes, so Senator, and I think some of the press reporting of that number was maybe a little confused.
Okay.
So 1.4 billion, which was I think the number in the press,
Yeah.
was about at any time amounts which had been paused.
Yes, we've
Some-
had this discussion
Yes.
before in the COVID committee. Yeah.
So some of those amounts have ultimately been found to be payable and completely fine and have been paid. To give an
How
order,
many of the 1.4 bill? Is that a moving? It's a moving
so
figure.
1.4 is a moving figure. It's
Yep.
always growing.
Yep.
At an order of magnitude, we have stopped a bit under 200 million in a permanent sense.
Right.
We're currently looking at about another 100 million. And we have also stopped future claims of about another 350 million. So that's where we've found that somebody is ineligible and we've chopped off their future claims.
So someone in the 200 million who you've stopped in a permanent sense has a ongoing impact in a future sense.
That's right. And also some who we have found have made honest mistakes. We have made, particularly early on, we made the decision not to try to claw back amounts,
Yep.
but just to stop them going forward. We have clawed back about $120 million in payments that we had made and clawed back.
Out of total payments,
So we've, as of today, we're at, I think, about 69 billion.
so 69 billion, the clawbacks, 120 million, are they for who, you've got some discretion about how you apply that, do you?
Yeah, so we generally only claw back where there's been a deliberate or reckless mistake. Where there's been an honest mistake, we, particularly early on, we made the decision not to, and particularly there where the employer has claimed in good faith, has passed it on to the employee in good faith, so it's not financially benefited. We made the decision to let those let those go, but just make sure that they didn't get future claims.
Do you know how many you've let go? Do you track that?
I'd have to take that on notice. I
you?
don't have that figure with me.
Yes, and who makes the decision? What's the process for the discretion? It's presumably ultimately Mr Commissioner, but delegated?
Yeah, so it's delegated. We have a special economic stimulus group headed up by Deputy Commissioner O'Halloran. Under his group, there's an assistant commissioner who's responsible for compliance.
Mm-hmm.
Various settings have been at a broad level have been set in that group, and then it's the decision in a particular case will be for an individual case officer with appropriate escalation.
And have you had any external, I imagine, are you utilising existing sort of compliance frameworks for your assessment of this? Because it is an unusual program, and also, I guess, hang on from that, have you had any external validation of your processes?
Yes. So on the first question, we're obviously informed by our history as to what works in a compliance program, what cases, for example, are economic to pursue, things like that. But it is different. It is a grants program with different, it's different from tax.
Yeah.
It's not just it's not a negative tax. It's fundamentally different from tax. So there was senior consideration of those parameters. In terms of external review of those settings in the program, we have had, and I think we're mid a review by the ANAO, and on their initial review of how we implemented the JobKeeper program. Actually, can I say, I might, maybe Deputy Commissioner O'Halloran can tell me what the status of that review is in an official sense, but no concerns have been raised in relation to our approach.
On the initial rollout of it, this is about making decisions about what to claw back and what not to claw back. Have the ANO looked at that?
My understanding is that that's part of their scope as to how we would approach the risks of the scheme. I don't know if James, you have something to add.
Yeah, so Senator, if I could just fill in a couple of things. The ANAO audit that's underway relates to the ATO's implementation of all its economic measures, with a particular focus on its risk frameworks, its approaches and its governance. So it does pick up not just JobKeeper, but JobKeeper is probably the largest one. And so therefore some of our settings around our risk, when to release things, when to hold things, and what's the governance around that is part of that review. In an official sense, we haven't received the Section 19 report as yet, which is the report, which is the first formal report. So I'm not sure I can take it much further than Mr Hirshhorn, or I might get into trouble from the ANAO,
Yeah, sure.
But certainly they've been in for 4 or 5 months, and I can assure you they've had full access to everything. Just in terms of what you've been describing as the clawback arrangements and the accountability, a couple of quick things. Certainly because of, as you've said, the unusual nature of the policy intent and the settings, balancing a high assurance but also an appropriate assurance for a economic stimulus measure, particularly of this scale. 2 quick things. One is we do have a panel that we've set up, which is chaired by one of my SES, where there is in fact a decision to claw back, as we'd call it, because that's actually needs to be looked at in the context and the behaviour. All the way through this exercise, just by the very nature of the applications, we have, as perhaps the government even intended, you could tell by the legislation and also by the nature of these things being non-tax, as Mr Hirshhorn described.
Okay.
Clearly there have been a lot of honest mistakes,
Yeah.
and
Okay.
therefore that pattern has played through.
Thank you, Mr O'Halloran. I've only got about 5 minutes left. I've got to get through another area. But how many companies, how many firms received JobKeeper when they were ineligible? Have you got that figure? You've given me the figure of the 200 million relating to a permanent stop. So I presume you've got a number of firms.
Senator, can I take that on notice, because we sort of reject applications at a variety of stages. Some don't even get into the system, some apply and we reject before the first payment, some we reject after. I might take it on notice so we can give you
If you could break that down, and also specifically of the ones that you have classified in the permanent sense to be stopped. Okay, in just in relation to fraud, you've got that red flag system, I think, don't you? There, where you, you know, if there's any suspicion of fraud or reported fraud, it has the red flag is raised internally. Is that right?
Yeah. So Senator, particularly, let's say on identity fraud, if we have a suspicion that there is identity has been compromised, we effectively put a caveat on that taxpayers' affairs.
Has the fraud detection and investigations team identified any increase in suspicious activity during the COVID crisis in relation to that?
So, Senator, we've been very focused on fraud. Obviously, there are new mechanisms of potential fraud. So across all the programs, we have found, so we've previously testified on the level of fraud in the ERS program, which is at about 0.3% of applications on our count, which is a very, very low level of fraud. We have also been looking at JobKeeper and Cashflow Boost and have not found systemic fraud. We have found there have been some individual opportunistic frauds, but we have not identified a high level of fraud. And part of that was the design feature of the measures, which were designed only to be available for those who had a good lodgement and a good tax history, which made it harder for people to resurrect dormant entities or...
So I think your answer is no. You haven't, the investigations and fraud team haven't identified any increase in suspicious activity during COVID.
We have not found, it's been a low level of fraud on these programs. And
what about red flags? Have you had more red flags?
So we've had more, so for example, through the early release of Super, we have received a variety of suspicious matter reports from AUSTRAC. There has also been a spate of, when an organisation has its payroll data amongst other data hacked, there have been a few hackings of companies which have meant that we have put more red flags on identity files.
Okay, can you give me, what the level of increase might be then in red flag activity?
So, Senator, I'll take on notice, but I might give you, if it's possible, the number of files that we have, let's say the number of taxpayers that we have put a identity warning on over time, if that would be useful.
And also whether I really am. Like, it's 1 minute, but seriously, it doesn't. It is estimates as well. Like, if we go 3 minutes over, I'm really sorry, Minister, but we are here beyond your departure. I am trying.
Indeed, we are.
I am trying. Okay, so you'll take that on notice.
I'm in the committee's hands, as always.
Do you have enough resources to investigate suspicious activity and potential fraud?
Yes, Senator.
Have you made any decisions internally to reduce the number of investigations relative to red flags due to staff constraint?
No, Senator. So even in the height of COVID, where we did divert some resources from compliance activities, we have very deliberately maintained our resources around fraud type activities.
And so on notice, you'll be able to tell me whether the difference in red flag or the increase in red flag during COVID?
Yes, so Senator, we'll try to give you some longitudinal data which gives a sense of that.
All right, thank you. 30 seconds early.
Well done. Minister, I formally farewelled you from the Finance Committee last week, so I won't subject you to that again. It's been a long farewell. Simply to say thank you on behalf of the committee for your service to this committee, to the Parliament and your country, and I know we all wish you well in your next endeavour.
Thank you, Chair. With your indulgence, I might make a few remarks.
Please.
Chair, colleagues, it has been a real privilege to serve on this committee as well as, of course, on the Senate Finance and Public Admin Committee over many years. I've participated in 17 estimates sessions in opposition, bowling up questions to the government of the day, and I've participated in 21 estimates sessions in government, providing the best possible answers. This is such an important part of our democratic process. Obviously, after a budget and on 2 other occasions throughout the year, testing, probing, challenging the decisions of government, scrutinising the performance of government against previous commitments and forecasts, and indeed putting the spotlight on any issues that may arise from time to time. I mean, it's such an important process to ensure we have the best possible decisions from government at any point in time, that government of the day is kept on its toes in terms of its performance, and indeed to make sure that we have the appropriate levels, the best possible levels of integrity in our governance arrangements. And let me say, and I say that with a lot of goodwill to my friends and colleagues in the opposition, I found as an opposition senator that the Senate estimates process is an amazing opportunity for a future minister to get across all of the issues. And having been here in this room over many years, let me say a particular thank you to our outstanding world-class public servants who've answered my questions to the best of their ability from opposition and who've supported me answering questions during my period in government. We really are very fortunate in Australia. This is my last occasion that I'll be with you in this room, but I'll continue to watch your work from afar as a committed as a committed citizen of Australia, committed citizen of our great country that wishes you all the very best for your future endeavours. Thank you so much for the way you've all engaged with me, and I wish you all the very best for the future. Thank you.
Thank you, Minister. The committee will now suspend. We'll return at 1 p.m. with the ACNC.